Thank you very much, Becca. Many thanks to Manchester University Press for organizing this very special event. I'm obviously very honored and very pleased to be moderating it. Well, a warm welcome to everyone. I see many attendees in the virtual room. So we're all here today to discuss the republication of the boundaries of international law by Manchester University Press. The original volume appeared 20 years ago, and it's today republished with a new introduction. I think that's something we need to highlight, because the two distinguished authors of that book will be commenting on the new introduction. So the book is real. It's just been published. It's here in front of you with the new introduction. I've been told by Manchester University Press to remind you that it's sold at a very friendly price, and of course we will all welcome it. I'm honored that the authors of Boundaries, Hilary Charlesworth and Christine Chinkin, are with us today. Very much to both of you for making yourself available for this, what is meant to be a discussion, and I'll say a few words about how we're going to proceed in a minute. But before that, let me just say a few words about the boundaries of international law. Well, obviously, this is a book that needs no introduction. It's a reference book for I believe the entire field, even in more orthodox circle. I believe that the book has had an impact, or at least was acknowledged. I think no one would challenge today that the Boundaries has really cleared the way for a new and enormous trend of much needed critical scholarship. It has inspired a whole generation of scholars about the possibility to move boundaries, as the title indicates, especially when it comes to gender. And it's because of the importance of the book, its scholarly, intellectual, disciplinary thrust, that Professor Ina Scobie and myself decided some years ago with the support of Manchester University Press, to republish it. And we thought that the republication was warranted, also because the original version went out of stock. And we were thrilled that Hilary and Christine accepted our invitation to republish the book with a new introduction. And this is what we will be speaking about today: the new introduction, and as well as the book, its main argument, 22 years later. How are we going to proceed for the next 52 minutes? We aim at finishing by the hour. Well, we've decided against having formal presentations by the authors of Boundaries. Rather, we'll have a more interactive type of engagement with the book. I will kick off with a few questions to Hilary and Christine, and after that we will open the floor to the audience, and I'm very happy to see many people with us in the virtual room. So that's the plan for the next 52 minutes. So my first question, something to be expected, I believe, is a question about what you've just achieved, revisiting a 22-year-old and adding a new introduction. So my question is, how did you feel about revisiting the book 20 years or 22 years later, and how did you feel about writing a new introduction?
Okay, shall I start then, Hilary? And thank you very much, Jean, for your introduction, and thank you, Manchester University Press, for putting this on this afternoon. And as you said, good afternoon, good morning, whatever time zone. First reaction, very old. Can it really be 20-something years later? In many ways, it seemed far less, in many ways, far more. More seriously, quite clearly, the international landscape has changed enormously in the decades since the publication of Boundaries. And Boundaries was I think at a time still of quite considerable optimism and the promise of progress in international law. And I think we both felt at that time the optimism of using international law for progress with respect to the inclusion of women's lives into international legal frameworks and analyses. Things have changed enormously in the 2 decades since. And I think that when you first made the suggestion of a new introduction, we had a decision to make. And we spent quite a long time discussing this. On the one hand, quite clearly in that 2 decades, a number of things have happened with respect to inclusion of women. So we could have pointed to new jurisprudence from the various regional human rights courts, new cases from the International Criminal Court. We could have pointed to new general recommendations from the CEDAW Committee, from the other human rights bodies. Areas of international law that we really did not look at in boundaries, where there had been developments. We could have pointed to language, for example, in the Arms Trade Treaty and in discussions around weapons. We could have looked at the way environmental issues have started incorporating ideas around gender. So there was a lot of detail that we could have looked at. And we did have to decide, well, are we going to try and do an introduction that points to some of these various developments, changes, and so on? And I think, in fact, Hilary, we began doing that at one point and found ourselves really totally overwhelmed by detail. So then we sort of stopped and said, no, this is just not what we can do in such an introduction. So instead, we turned to thinking about, well, how has the changed international landscape impacted upon international law from the perspective of feminist approaches? And so rather than getting into detailed updating, try to address a few themes and try to bring them together with around our thinking today.
Yeah, if I can follow on from Christine, and thank you. Let me echo Christine's thanks, Jean, to you and to Ian Scobie very much, and of course to Manchester, who long ago, well, 22 years ago, I think really at the behest of Vaughan Lowe, really took a punt. And I just want to acknowledge Vaughan Lowe's very early support and enthusiasm for the project. But I think, as Christine said, we had a very difficult time. It took us about as long to write this new introduction as it did the book, I think, because we not quite we agonized over the type of approach. And I think one way perhaps of summing things up is that what we felt was, in a way, there are certainly over the last 22 years, there have been many changes to what we could think of as the primary rules of international law, subject matter areas that Chris has just sketched there. But what's critical is that there's been very little change to what might call these secondary rules of international law, the ones that sort of set up its structure and how one recognises principles of law. And so, you know, critical issues such as jurisdiction haven't changed very much. And we point in the introduction briefly to some of the International Law Commission's work, recent work, where in a way we can see that very important and prestigious body, a gatekeeper in international law, still reverting to secondary rules of international law that exclude a lot of issues relating to women's lives. So it was, I think it was, we could have written a very upbeat success story sort of book. Here's the way that women's lives are being addressed in specific subject areas. But it seemed to us that the story, if one looked at it rigorously and honestly wasn't quite the fairy tale story that it might be seen.
Thanks a lot. That's absolutely fascinating, and I'm very thankful that you're so open about the genealogy of the book, as well as the context in which both the first book and then the republication were written. I think I'm sure our audience today will appreciate. And I also want to point out that the breadth of the book, which you have touched on, which is a book that grapples with, of course, gender biases, both in the primary rules of international law and the actual institutional practices, but as well as in the third categories, in the secondary rules, in the structure of the language of international law. And I think this is why the book has actually been of so much relevance for very wide readership. But before actually we continue our discussion on this, I think it might be useful for audience to know a little bit more about the new introduction that you've just completed, and I'm keen on asking you what the main argument of the new introduction is. So could you tell us a little bit more about the gist of the new introduction?
Okay, well, I think Hilary's actually more or less answered that already. I mean, the gist of the new introduction is essentially holding to the argument of the original book, that the conceptual and institutional borders of mainstream international law continue to exclude women's lives from their structures, from their processes, from their concepts. And as Hilary has just pointed out, the secondary rules, those real core principles of international law, jurisdiction, sovereignty, sources of international law, those all very much remain untouched. So yes, we have changed vocabulary. We'll find in various areas of international law the word women. I mean, that never occurred, I don't think, before. References to gender in various ways. Many new institutional practices. So we will find, for example, a special rapporteur or special representative of the Secretary General on sexual violence and armed conflict. We'll find gender advisors in UN peace operations. We'll find women protection officers. And so there's a whole number of very specific positions. But that, say, the basic argument is that this does not really impact upon the structures, processes, the power bases of international law. And this is not just about inequalities relating to gender. This also, of course, goes to the other structural inequalities of international law, those founded upon race, upon colonialism, upon sexuality, the interplay of the various forms of inequality. Perhaps what I might just do very quickly, though, is if you say people would like to know what's in the introduction, we essentially have four main sections in the introduction. We reflect upon the term feminist analysis, and feminist analysis, how it's been applied in international law. And I think both of us are very excited by writings by many new young scholars who have been innovative, have applied feminist theories in a number of ways and to different areas of international law, areas that we didn't look at all. So we try and do a bit of an overview of what we mean by feminist analysis. Then something that we really didn't do in the original, in the first issue of the book. The first issue, we modeled it essentially upon a classic international law text, Brownley's Principles of International Law, because what we wanted to do was to say, look, here is the classic framework of international law. Now, where do women's lives come in? So what that excluded, and what we think is a really important part of feminist analysis, is the work of feminist activists, and feminist activists going certainly back to the start of the 20th century, and the ways in which different movements, social movements, feminist women's organizations have, through the time of the League, through the interwar years, then through the United Nations, looked to the international framework hoping, I think, to find a more emancipatory process through international law than they found in sort of often very conservative national legal systems. So we do a bit of an overview of feminist activism. And then Hilary just said, you know, the fairy story, the good success story. We then took as an example to make our basic point, an area that to some people is viewed as a success story, the Women, Peace and Security agenda, which began shortly after the publication of Boundaries, Resolution 1325 in the year 2000, 10 resolutions of the Security Council, a whole new area that has emerged. And use that to show that, yes, while there is this new innovation, in fact, as we keep saying, the various structures really haven't changed. And then we end with some looking forward sort of type strategies. Hilary, do you want to pick up?
Well, I think that in some of our discussions about this evening, if I can remind him of his language, Jean had questioned us, saying when he'd read the introduction, he'd found it cynical, and I was quite struck by that, because I think it wasn't a word that I associated with the introduction, or we certainly didn't intend to be cynical. If cynical means, and I have consulted a dictionary this afternoon, the implication that any action must be in self-interest, that it's always, so I think the suggestion would be that we were just implying there was, as it were, a cabal of men just constantly acting in their self-interest, that was the story of international law. Of course, I'm simplifying Jean's more subtle point, but I think that we certainly weren't trying to imply that. We wanted to show that it's easy enough. I think what we hadn't realized 22 years ago, well, perhaps I can just speak for myself, because Christine may have been more advanced than me in this respect, but I think we thought, look, if we just point out that there are so many fields where women as lawmakers and women's lives as the object of laws have simply been excluded, we point that out, scales will drop from everybody's eyes and they'll say yes, 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 and then things will change. And I think we really did have an idea that once you'd pointed out even quite basic issues about inclusion, representation, that these would be so obvious, and then, as I say, all the principles would change somehow inevitably. And what I think over the last 22 years, and something that we try to communicate in the new introduction, is that this quite complicated move of, as Christine said, the adoption, the absorption to a certain extent of a feminist vocabulary, certainly if it's not feminist, at least it's women-centered vocabulary, which does give the appearance of change. But when one actually studies, and in the introduction we take as our case study here, the Women, Peace and Security agenda, one sees that that move is quite complicated and that it's very easy to co-opt in line with other agendas. So, for example, after, as Christine said, after the attacks of 9/11, this has meant that women have been brought into the area of international peace and security, in a sense, as a vector, as it were, to counter violent extremism. So one finds sort of enthusiasm about involving women in programs, anti-terrorist programs, in a way, the absorption of women, because that's very instrumental, that seemed to sort of be a good thing instrumentally. So these are ambivalent forms of progress, I think, for women. And then yet one finds in some of the central international lawmaking bodies that women really remain at the edges. So taking the International Law Commission, for example, to see that when the new commission regroups next year in 2023, I think it's still 5 out of the 34 members are women. So for all this talk and attention to feminist agendas, we're still not seeing women actually coming into the heartland of international law. I don't know if we've lost Jean, but perhaps he's there, very visible. We can ask each other questions.
But can I, Jean, are you there? Oh, shall we carry on talking, Hilary?
Well, I can ask you a question.
Well, I was just going to say, could I come in on what you were going to say, what you were saying as well? Because you were talking about, women not being in the heartland of international law, still not being so, even where numbers are. I mean, there's been a temptation, hasn't there, to play the numbers game by so many institutions, and that hasn't led to real change. But I was thinking that, even where we seem to have had change with a particular regime, progress cannot be assumed. And I think we were talking about this earlier. I was going to give the example of the Istanbul Convention. The Istanbul Convention, violence against women back in 2000, when we wrote Boundaries, violence on women looked as though, yes, that was moving as an area where there was clearly going to be progress and would be integrated into international law. And indeed, we have the CEDAW committee asserting in 2017 that violence against women, prohibition of violence against women, has indeed become a norm of customary international law. That again looks like real progress. And the Istanbul Convention, said to be the gold standard very frequently of combating violence against women, was adopted in 2011. And again, progress looked good. But then what have we had over the last few years? We've had Turkey withdrawing from the convention, which I think has sent shockwaves around Europe, that one of the countries of the Council of Europe would withdraw from such a crucial convention for women's lives. My own country, the United Kingdom, announced in 2012 that it was going to become a party to the convention. 10 years later, it has at last announced that, yes, it will in fact be ratify, taken 10 years, but it's going to ratify with reservations. And one of the reservations relates to the article on migrant women and the provision in the convention that countries should give independent visas to migrant women who experience violence, to ensure that they are not deported, for example, if the marriage breaks down or they want to leave a violent relationship. And a reservation of this sort still, I think, goes right to the heart of a commitment under international law. It is drawing and further upholding inequalities. It is saying that the international standards that have been developed for the guarantee of all women's rights, in fact, are not going to apply to all women within the United Kingdom. And quite clearly, the country feels, the government rather, feels that this is still something that they can make reservations to. I mean, we know, again, it's something we discuss in Boundaries, how reservations have eaten into and undermined the effectiveness of CEDAW. And I think we had hoped that this was something that was passed. Well, it looks like perhaps it isn't.
Yeah,
so
I think we can just chat.
Well, we're very good at doing that.
I think what you've said reminds me of, I think we quote Nancy Fraser in our new introduction, who talks, I think, very powerfully. She says what we seem to have, she's come up with this idea in another context, but I think it's relevant to international law, is what she calls a strange, shadowy version of feminism that feminists can't wholly embrace or wholly disavow. And so it's curious I like that idea of a shadowy version of feminism that some of these activities rely on, and I think women's groups, civil society are sometimes made to look ungrateful, that they're not thrilled by each minor development. But when one looks at it over a period of time, it seems more problematic. I suspect we may have lost Sean, but we did identify some questions.
I'm actually here, to be honest. It's just the camera is not working, so I'm here in my capacity as a ghost.
A shadowy version of the
shadowy version of Jean Dapoma. Jean, go ahead and please pose your question.
And I'm afraid we've been a victim of one of these first world issues these days, something we're all accustomed to. No, I missed a few minutes of your fascinating exchange, and something I wanted to return to is these bits. I called it cynicism earlier on, and I'm glad that you've rebutted me. But I still felt that in the new introduction there was at times a bit of disappointment as to the degree in which international law had changed. I mean, you have this very striking sentence where you say in the introduction, in the new introduction, boundaries became at best a footnote in mainstream text. It's a very powerful sentence. You also write, 20 years later, the international legal order emerges as an ambivalent site for the advancement of women. I mean, these, of course, I think today in our exchange, you've really put the emphasis on the upbeat and the positive side of all this. But I think you've rebutted me very, very convincingly. But I felt that there were times in the introduction where there was a bit of disappointment about the conservative character of international law, despite all international lawyers acknowledging, I believe, that something is in need of change. So do you feel I read too much in the new introduction?
I think we are disappointed. At least I certainly am. Maybe I shouldn't talk for Hilary. I shouldn't talk for Hilary, but I think we are. I mean, but it's part and parcel, though, isn't it, of I think, a very difficult moment for international law in general, and particularly for human rights law at the moment. There are attacks on human rights in so many different ways. And as ever, I think when there are attacks upon legal structures, legal norms, it seems very often to be represented particularly through the lives of women. So we see, just for example, higher rates of threats and actual killings of women human rights defenders. I think we refer in the end of the introduction, because we finished it during the pandemic. We see, when there is an emergency situation or a crisis within the world. Now, Hilary, of course, has written on crisis, so I think I want to hand back over to her. But what we saw during COVID was very clearly both increased rates of violence against women, greater inequalities coming through. I mean, I think that to feel disappointment with the current international state of affairs and both the inability of international law really to get a grip on the state of affairs and make a real difference, and the attacks on international law itself coming down further into particular areas of international law, particularly those that impact upon women, I think we'd be being very naive not to be disappointed. Am I being too strong, Hilary, or do you agree?
No, I do agree, and I think that one observation I'd make is that especially because by and large in most legal systems, and certainly in the international legal system, there is acceptance of the idea that there is or should be a norm of non-discrimination against women, just to sort of focus on women as a category there. And so people understand that, but then I think generally the understanding is, well, this is designed to counter overt discrimination, and it's there for cases where one can think of, for example, I'm thinking of my own country in Australia, men's clubs that simply say we will not admit women members. So most, I think, international lawyers would concede that prima facie there's something problematic there. But I think really generally international law in a number of fields has dealt with a fairly limited notion of non-discrimination, and it's quite an individualist idea of non-discrimination. So people can certainly understand, okay, we're not allowing those people in because they are women, but it's been much harder, I think, for the communication of a broader idea of equality and non-discrimination that would include structural causes of inequality. And I've encountered in a number of international legal settings, including the academy, international law, civil society, and so on. Many people would be shocked if you say there's a culture of discrimination against women, because most people would assume there's only a problem if there's overt discrimination. And I think there's been too little attention to international legal cultures that really, the ethnographic research it may be, that really tries to understand why we still have the reproduction of the international law hierarchy that we do have. So I think we need to, that's perhaps an academic task, or that something we need to communicate better what the problem is, and to try to deepen the understanding of the sources of inequality, that it's not just a question of eradicating overt discrimination against women or against anybody on the basis of gender.
Yeah, and I think what you're saying about the need to deepen our understanding of these structural inequalities and the structural discrimination points to the need for works like yours. And I think it shows how timely boundaries remains, especially against the backdrop of this, what you've called this culture of discrimination informing international law. So maybe let's maybe move the discussion towards the way in which you envisage addressing these structural discrimination, this culture of discrimination, as you put it, and maybe we could start with the very idea of a book as a book, or the idea of a book as a tool to intervene in the problems of the world, including into problems of discrimination. How can a book like yours, like Boundaries, and that's my next question, how can a book like Boundaries address and intervene in the problems of women in the world in a very practical way?
Well, of course, when we wrote Boundaries 22 years ago, we were both academics, and writing about problems was what we did. That was perhaps that was the field in which we both felt most comfortable. And of course, since then, our lives have changed. Christine has done a huge amount of work with civil society groups. So she has, and also as an advocate and expert in various international court cases. So I think having a new appreciation of arenas in which change is possible. And I've been involved in not nearly such a broad range of arenas, but in different arenas too. But it strikes me, however, that I remember my wonderful colleague at the Australian National University, John Braithwaite, used always to say, there's nothing so practical as a good theory. And I think that's a profound comment. I think that if one can try and work out what's going wrong in a slightly more abstract way, one can, it's relatively easy just to chronicle problem after problem, but perhaps the time and the space one gets in the academic world to stand back a little bit and to try to understand in a theoretical way what's going on, I think that can be valuable. So we did that because that was the only thing we really knew how to do. We didn't know how to do journalism or make films or do an artistic work, but we knew how to write academically. So we were just, if you like, just ploughing that field that we knew well. But I know myself how valuable it is, and even in my current work as a judge, when you read something that offers a different theoretical perspective, it's not just a whole series of examples. It can be enormously valuable to conceptualize a field and try to understand the way that particular principles operate within a particular field.
A book is a tool, isn't it? A tool like any other tool. And where Hilary has just finished, it is explaining how it can be a tool for use by judges and judges in different settings. I think I've seen it more as a tool in the hands of activist organizations and those who are advocating, lobbying, campaigning, very often have said that, you know, they know where they want to get to, but what they haven't necessarily got, and what to some very small extent Boundaries and some of our other writings may have given, is a framework that enables them to put a case to whoever it is, the policymakers that they are trying to influence. And I think we shouldn't forget either that international law is still a language that government in particular understand and use. And so being able to try to frame particular objectives with a backing of international legal analysis, theoretical analysis, I think has been useful. And I think sort of way back before we wrote Boundaries, but when we first wrote the article, which was a sort of the real origin of Boundaries, the feminist approaches to international law. And I think we were quite taken aback, but also very pleased to see the way in which a number of civil society organizations used it, particularly with respect to the campaign for bringing violence against women into the international legal order. And clearly a book is not the only tool. There are many others, but I think it is one that should and does take its place alongside others. And as Hilary said, maybe just to add on to that, say, as Hilary said, that was our space, that was our comfort zone, that's what we knew how to do. But what we're seeing now is, for example, the way in which we can take part of, say, a theoretical book and put out a much shorter, pointed blog. And I think using these different forms of writing, we might think about a blog post from the introduction, for example, Hilary, can make the message much more quickly, and I think again can help. But what we also, I think, have to remember is, you know, that the majority of the world's illiterate people are, of course, women, and a book will never reach them. But that I think it's also important that even within that restriction, that a book has to be written in language that is as accessible as possible, even when it's an academic publication.
Thank you. That's terribly important indeed. And a book surely is only a tool, but it is a very important tool. And I obviously share your beliefs in books' performances, and especially in book world-making role with respect to, of course, judges, lawmakers, but also in terms of the imaginary of everyone. And I think that we should never underestimate the imaginary making role of book. It creates a world of possibilities upon which we can start acting. Now trying to be, and that will be my last question today, trying to be maybe a bit more concrete. But boundaries, as I think our audience and all the readership of boundaries understand, boundaries is a book about moving boundaries. And it's about moving boundaries rather than doing away with completely with the existing thought categories, because as you said, this is possibly not an option. But so Boundaries is a book which offers a catalog of strategies to move boundaries. So trying to be concrete here, what strategies might be used to redraw the boundaries of international law? So what would you say to the many scholars that are listening to us today? What would you say in terms of strategies that we should use to move these boundaries, as you call for in your major opus?
Well, I think what we're trying to call for, obviously in our writings more generally, and certainly in this new introduction, is constant questioning, not of and our field is international law, so all aspects of both the institutions and the principles of international law. So that's obviously, as we've been saying, a very important aspect that comes from the academic work, just to give people some basis on which to question. But we also consider briefly the ideas that have perhaps become grouped under an umbrella which is being called prefigurative practices. In other words, practices that model in small parts sometimes the way that you would like the world to develop. So there's a lot of literature on prefigurative practices. So, for example, it's sometimes said by scholars in this field that the women at Greenham Common in the United Kingdom, for example, when they set up their camps, were trying to model different social orders and ways of living that they were trying to achieve. And I think we can think of these prefigurative practices in law, just to give two different examples. In the field of international law, we've 3 years ago, Loveday, Hobson and Troy Lavis they edited a wonderful collection in which Christine and some co-authors have a fantastic chapter on feminist judgments in international law. So just to embarrass Christine and reference her chapter, which is a feminist rewriting of the famous Lotus case, that case beloved of international lawyers. Christine and colleagues sat down and rewrote the judgment using feminist ideas that were available at the time. They renamed the case, the Bozkurt case, after the Turkish boat that was involved in that, and offer a way of recasting that judgment to take into account women's lives. There's also, in the context of the International Court of Justice, there's a feminist rewriting of the Lockerbie case of 1998. So I think the Feminist Judgments Project is a fascinating one because it's taking cases that are deeply familiar to international lawyers, and just there are many different ways of doing this, but of rewriting them in ways that would be consistent with having more women in the judiciary and more understanding of the detail of women's lives. And another prefigurative practice, and this is a segue for Christine, who knows much more about this than me, has been the use, for example, of people's tribunals in international law. And because Christine was involved in the Tokyo Tribunal, I might hand that over to her to talk a little bit about the experience of these people's tribunals as a practical activity that has, even many years after the Tokyo Tribunal, still continues to have reverberations. Chris, over to you.
I don't quite know what to say about the people's tribunals. Again, it is that idea of let's look at the world as if it were the way we want it to be. And so with the Tokyo Tribunal, essentially what we did, this was around the failure of the international legal system to award, failure of Japan to recognize the harms that were committed against the so-called comfort women, and the failure of the international legal system to offer any avenue whereby the harms that were committed against them during World War II could be recognized, and therefore reparation made to them. And so it is taking the framework and the framework of international law as it was in 1945 and saying, well, how could it look if in fact our focus was on gender justice, on ensuring justice to those women and interpreting the law as if the focus was to give reparation to them. And I've always been quite surprised at just how powerful, in fact, that is. And I think to go back to what Hilary was saying about the Feminist Judgment Project and the Tokyo Tribunal, in fact, we've just made a documentary about the Tokyo Tribunal, and they are enormously useful pedagogical tools that if we think about the next generation of international lawyers and presenting them with these alternatives and thinking, well, how can these alternatives in fact suggest ways forward, then I think that that is an important strategy. And so combining the previgerative with our other main function, the teachings, academia type function. But I think we also shouldn't forget strategies that actually do still take the system as it actually is. And Hilary mentioned earlier, giving expert evidence or amicus briefs. I mean, I know that recently there's been a major exercise of a series of feminist briefs being submitted to the International Criminal Court with respect to the appeal in the Ongwen case. Now, of course, I don't know how the court will use those, but again, presenting those arguments and showing those who are in the position to make decisions now in the formal structures of international law, I think is also something we shouldn't ignore and shouldn't completely discount. And perhaps to bring together that comment with the People's Tribunal, there's been a lot of literature around the concept of transformative reparations. And I think that that can be an extremely useful way in as well to identify what are the harms. And through identifying what are the harms, then saying, well, where is the law and how can the law be interpreted to address harms that have perhaps not been recognized previously? And in particular, this concept of non-repetition of the harm, which brings us right back to the notion of addressing structural inequalities, the political economy, the emphasis on militarism, all those various aspects that support the power structures as they are today, and say, how can those be transformed? So I think that if we look at the jurisprudence of the Inter-American Court of Human Rights, for example, while they're not necessarily presenting it in feminist type terms, I think they are looking at emancipatory transformative type language in those particular ways. But I also think that we're international lawyers and we've focused obviously upon changes to international law, but we also have to see how international law is one of the structures alongside the neoliberal economic system, alongside the prevailing militarism, and that we have to challenge and resist all of these together.
Thank you, Hilary. Thank you, Christine. I think that's extremely compelling and great. And I think you that these strategies are all of very, very different kinds and different natures, that they both at the linguistic and structural level, but also at the institutional level. Well, it's wonderful because it's also very hopeful, and I think that's a wonderful way to end all very short exchange, and obviously we could keep on for hours, but I'm quite keen on giving the audience the chance to raise questions, even if we will have to wrap up soon. I'm being told that questions should be thrown in the chat, or for some reasons, and it may be that I'm cursed, but I need any question on the chat. I don't know whether Hilary or Christine, you're able to see questions that have been thrown in the chat. I'm told there is one, but I don't see them. Hilary and Christine, do you see questions in the chat?
Yes, it's coming up now. It's a long one.
So let's read it.
When we analyse the problems concerning the rights of women today, we have the impression that the condition of women has further deteriorated: rape, murder, violence, harassment, despite the existence of treaties and other instruments. Don't you think that the international law has failed and that we should turn to other methods than law?
Can I perhaps say something there? Well, thank you very much for the question. I would just say that it's perhaps, I think in any context, we can never expect law to solve all the problems. Of course, we have national domestic laws, many of them prohibiting the type of conduct that you sketch there, these crimes, and of course they still continue. And but so law by itself, I think there's no context in which by itself it is enough. So to achieve change, to truly change behaviour and change patterns of behaviour, you certainly, I think, need legal standards, but you need a lot of other methods of compliance, that pressures that will induce compliance with those standards there. So I would say, I don't think we should give up on international law, but we also shouldn't put all our eggs in that basket. And I do recall many years ago attending a wonderful talk by the British feminist criminologist Carol Smart, and I just remember very clearly her saying, you know, it's better to be a feminist journalist than a feminist lawyer. And I've often sort of thought about that and thinking, well, perhaps should I encourage my students give up the law and go into journalism? And while I admire the great bravery of many journalists who've been extremely important in bringing attention to these things, I do think that lawyers have a great deal to add to the resolution of these problems. But it's unrealistic to think that could ever be enough by itself. And we have to, as it were, think about law as part of a fabric of regulation that can work best when it's supported by other pressures towards compliance with the standards. So that would be one response to your interesting question.
Yes, I don't think I've really got anything to add, except perhaps to say that, of course, the real problem is the non-application of the law rather than the law itself, impunity and non-accountability, and the failure of so many states and institutions to ensure the applicability of the law. And I would also just add, thinking about your comment about journalism, Hilary, how often have you must have been, as I have been, rung up by journalists who say, I'm about to write an article, could you please fill me in on the law so that I can substantiate the article? I mean, it's working together, isn't it, again, with these various tools that is so important.
Thank you, and I must say, if I may venture a comment, it's that I do agree that the argument of a failure of international law is actually a risky one, because it can be instrumental into an excuse for not trying. and it can actually nourish a feeling of resignation. And I'm very happy to hear you turn down that this idea of a failure of international law. So no, this is very insightful and inspiring. I wonder whether there are other questions from the audience. I do appreciate that we've reached the hour, and we had promised the audience to finish at the hour. So unless I see in the next 30 seconds a question in the chat, I will have to bring this to a close. Obviously, not without thanking our two authors and obviously the distinguished speakers today. I'm very grateful that they made time for this. We know that they're extremely busy. I'm also happy that I disappeared from the screen, because it made sense actually that the spotlight was only on the authors of The Boundaries of International Law, whose republication we are celebrating today. And of course, big thanks to Manchester University Press for making this possible, and many thanks to all the participants today. We were, I think, at some point 30 participants. This is great. There will be a recording that will possibly be made available. So thank you all, Christine, Hilary, many thanks for not only writing the new introduction, but for contributing to our debate today. We hope to see you all very soon, face to face, when we're back to normal. So thank you, everyone, and have a good night, a good evening, or a good afternoon, wherever you are in the world.
Thank you very much.
Thanks, Sean. Thanks, Christine.
Yeah, thank you. Yeah, and bye, Hilary.